Okay, it's 5 o'clock, so I call the Policy, Resolution, and Legislative Committee of the Board of Education of the Wausau School District to order. During this meeting, board members will, in many cases, be hearing information presented to them for the first time. Their responses will, in many cases, be extemporaneous and should not be considered either their final opinion on a matter, nor should any opinion expressed by an individual board member during any meeting be considered the opinion of the board as a whole, unless it is presented as such by the presiding officer. Okay, the second item on our agenda is
You were saying?
the approval of the minutes. I seek a motion to approve the minutes from November 12th, 2018.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Opposed?
Abstain.
And next is our legislative update. A lot has happened in the last 10 days, so it's a little bit lengthy. Last week, the Wisconsin legislature held a lame duck session that has been making national headlines. Wisconsin Republicans introduced bills that would limit the power of incoming Governor Tony Evers and incoming Attorney General Josh Gall. They worked through the night to pass those bills early on December 5th. Despite public demonstrations and comments from the public, none of whom supported the bills, the Republican majority in the Assembly and the Senate passed the controversial legislation anyway. According to reporters from the Milwaukee Journal-Sentinel and USA Today Wisconsin Network, here are some of the things that will be affected. Early voting. Bill passed limits early voting to 2 weeks. A similar limit was found unconstitutional in 2016, and Democrats have threatened to take legal action. Again, healthcare. Lawmakers put themselves in charge of litigation, allowing them to keep alive a lawsuit to overturn the Affordable Care Act, widely known as Obamacare. Public benefits will be affected. This legislation forces Evers to get permission from the legislature before asking the federal government to make any changes to programs that are run jointly by the state and federal governments. That would limit the governor's flexibility in how he runs public benefits programs. Crime fighting. These bills give lawmakers, instead of the Attorney General, control over how court settlements are spent. Taxpayer-funded lawsuits. These bills make it easier for lawmakers to hire private attorneys at taxpayer expense when they are accused of violating the open records law or other statutes. Pardons. Require the Evers administration to report to the legislature if the governor pardons anyone or his aides release anyone from prison early. Job creation. Gives Republicans more say over the Wisconsin Economic Development Corporation, including over its enterprise zone program that gives tax breaks to individual businesses. WEDC's board, rather than the governor, would appoint WEDC's leader until September. Although these items may not seem to affect schools directly, one item that I found directly does. Among the items passed in the legislature are provisions that would require the Wisconsin Department of Justice to deposit all settlement funds into the general fund instead of the common school fund, as designated by our state constitution. The common school fund is an important source of funding for all public school libraries in Wisconsin. And that's in our state constitution. Just to give you an example, you know that I'm a librarian at a middle school. I have 850 students. I get about $30,000 from the Common School Fund to buy library books and other things needed within our library to provide teachers and students with the learning tools that they need. So depleting that fund, only the interest on that fund is distributed to school libraries in Wisconsin, and the bulk of the funding is from land sales back from when Wisconsin became a state. So fooling around with that could deplete an important source for schools in Wisconsin. These items were not discussed during the campaign. The only issue that was part of the campaign that I could find was health care protection for Wisconsinites with pre-existing conditions, Overturning the Affordable Care Act would eliminate those protections. The state Senate on Wednesday morning did introduce a bill to protect people, to cover people with pre-existing conditions, but that bill failed, rejecting one of Governor Scott Walker's campaign promises. Many people, both in Wisconsin and around the nation, feel that this is a blatant power grab by Republicans and an attempt to invalidate the November election results. At this point, things are in the hands of current Governor Scott Walker, who has indicated that he would sign the legislation. He could also veto the legislation, or I've just heard, and I'm not sure if this is true, that if he does nothing by Thursday, everything passes. So I would encourage all citizens to make their wishes known to Governor Walker.
So Beth, just a question, as we go forward then with legislative updates, can we expect them to now cover all legislative action like yours just did? Or how are you going to do that going forward? Because 95% of what you talked about has nothing to do with schools.
Well, when it has to do with the fiscal health of our state.
But it didn't.
So are you saying that you would prefer that I only had talked about the school, the common school fund, and nothing unrelated to education
I'm
directly?
curious as to what your point or purpose was in discussing, in the way that you read it, the previous 19 items when only one of them had to do with schools. It's just because we've never covered that type of stuff before. It's always been school related.
Good point.
I'm curious why the change.
I thought this was historic event. The lame duck session was a historic event.
It's not happened in 2010.
Not like this. So,
Matter of opinion, but go on.
So I thought having a brief overview to educate us on what happened last week was important. If the board prefers that we stick only to things that directly affect school funding, I mean, I think what's happening.
I don't think it's our role to educate people on what happened in the political environment when everybody has that opportunity. I think it's our job to educate people how this impacts schools and their school district. No issue whatsoever. But when you start bringing all of these other items into it, it really looks like you have a biased agenda. That I have a problem with.
I have no problem with it. You spoke the truth. There was nothing in there that was
I was very
That's
aware
fine. Then,
of that.
Then as
so
long
I
as we're
tried to
going to do that
report
going
just the
forward,
facts.
regardless of what side you happen to land on, but I'm not going to sit here and listen to this be some kind of a soapbox for a particular ideology as we go forward just because things have shifted.
Well, I think it's safe to say we won't be covering everything going forward because we'd spend our entire meeting doing that.
Well,
so let's not go down that road.
I'm not going to stand for setting that precedent. I don't care where you fall. We've never done that before. It's always been school related.
Point taken.
Thank you.
Okay. We'll move on to policy 1630, rules and regulations for facility use and rentals. Keith, did you want to?
Was that one? Oh, sorry.
Yeah, that's you.
I'm trying to remember which one that was. That one, I believe, is, and correct me if I'm wrong, I think that's the one we had some restrictions on, was it beverages? Sorry.
Buying and selling food and beverages once renting our facility. We know that we have, for example, wrestling tournament where a youth group rents our facility and they have a concession stand, and it had in that policy that we needed written permission from the superintendent specifically in order to do that. And it's not very practical.
Right.
We rent our facility all the time and allow that.
And we have the booster clubs regularly doing that.
Yeah. That and other groups. We didn't think it was necessary to have written.
Thank you.
We're probably going to be bringing this policy back in the next several months for a couple other modifications on the categories of use and what we charge. And we're discovering other districts, they aren't getting rich renting their facilities, but they aren't losing as much as we probably are by renting our facility. We run into over and over again the situation where a group wants to use our facility, raise a bunch of money and give it back to us, but at the same time they're using our resources by using the facility. So finding that perfect balance between capturing costs and no more, no less. We'll at least have that discussion over the next several months. But this is a small edit
Yeah.
in advance of that.
Thank you, Bob.
Bob, do we run into any liability with regard to how the food is produced? I mean, does it have to be a state licensed kitchen for events like this?
We don't.
Okay.
The group that prepares it does, and they understand that.
All right. Not
They
our
tell us
problem
they
then.
understand that. But you're right. It's,
Yeah.
anytime you consume food, you're taking that risk, and anytime you serve it, you're really taking the risk, and groups need to understand that.
And Bob, what happened to the SWEDA contract that when earlier in the fall they're the theater group that every 2 years puts on that massive production with 6 or 7 school districts, and the last 2 years prior it's been at DC Everest, and
Yeah.
this year they wanted to do Wausau East, and there was a problem about how was that worked out?
If my memory serves me correctly, and there are other people here that are in the middle of it more than I was, that past practice has been upheld.
Okay,
The same treatment they got at DC Everest and the same treatment they got the last time they were in the Wausau School District, I think prevailed for this round.
okay. Tom?
We also asked them to provide, to ask us for a waiver, because that was part of that regulation, that a group could ask for a waiver. And so with them asking for the waiver and then looking at past practice, we were able to allow them to use it.
Okay, great, because there was, yeah, okay, that's wonderful, thank you.
Okay, any other discussion?
I had mentioned to Keith prior to the meeting, it's not part that's being changed tonight, but on page 3 under gymnasiums and field houses, it says that users must follow the first state law, and then it cites to a industry regulation about showing automobiles exhibitions or something.
Mhm.
So maybe that would be something, if this is coming back, that we could take a look at.
Want us to review that?
At some point. I mean, I don't know what it means, but maybe somebody else did at some point when it was written in there. It's not relevant to the change that's proposed tonight, but if it's coming back again, we can take a look at that and see if, why that's there, if we could clean that up.
Okay. Then I seek a motion to recommend to the full Board of Education the approval of the revision to policy 1630, rules and regulations for facility use and/or rentals.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Abstentions? Motion carries. Policy 4200, equal opportunity employment notice.
Good evening. I would like to preface this discussion to explain why I am here to present this. It's basically because I work in human resources, and without a director, I'm here because I actually helped facilitate and helped write some of these policies when Jeff Bress was here, and then also when Mike Schwei was here. So anyway, the reason that we're updating 4200 is mainly just to kind of spruce it up, take some unnecessary verbiage out, make it simple, and reference the policy that we have in order to have a complaint, or how to file a complaint, either be a formal or an informal complaint. So it was simply referencing 4205. I took out of this the information. It kind of conflicted with our policy about interpretation of this policy and who they could contact and so on. I thought it was repetitive and really not necessary. So that's the only change that I made in this policy. This is what is, it equates to an affirmative action policy, or an affirmative action claim that we have when we do our hiring through the district.
Any questions? Discussion? Okay, then I would seek a motion to recommend to the full Board of Education the approval of revisions to policy 4200, equal opportunity employment notices.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Item number 6, policy 4205, complaint procedures, employment.
Actually, this in its entity was written quite well, but there was two things I wanted to focus on. First of all, the formal complaint, the number of days. Simply stated, 15 days. I'm just looking at this. I thought I had put business days, but apparently that didn't come through on my change, so we'll have to catch that next time. If you were to look at the informal complaint, it referred to 5 business days. I wanted to keep that consistent is all, but we can work with 15 days. The second I wanted to do was add bullying to this as well, because on our form, we added bullying to the form. So I simply referred to unlawful harassment, discrimination, or bullying to this to represent, again, the actual form that they would complete. As far as human resources, I added a designee because oftentimes it's a human resources person. It's not necessarily the director that would investigate these type of complaints. Basically, and then I also cleaned up some of the different laws and the verbiage on the laws, updated the address for Madison and things of that sort. So it was pretty straightforward. Any questions about that you may have?
So in the informal complaint, 5 business days will stay 5, and then in the formal complaint, the 15 days will just go to 15 business days. So it's a friendly amendment.
Yeah.
Okay, that won't require a new set of permissions.
Okay.
One thing that concerns me is the initial reference to complainant. I think that there needs to be something to improve the precision there, because we go from the first sentence referencing the individual to then the second sentence referencing them to the complainant.
Exactly. Because the complainant can be either an employee or it can be somebody outside. It could be an applicant. It's not necessarily somebody that's within our district. But we could change the word. I mean,
No, I think the word is correct, but I think perhaps a definition. There might be a few other words that require some more description. I mean, you include bullying also, and that's unclear to me. Who's being bullied? If I have to go to another form, does this mean, it could be a variety of possibilities, but to me, on this policy alone, it's not clear.
I think we do that on purpose, and the reason why is we want people to, if they have a complaint, we want them to talk to us. We will determine if it's truly bullying by having that conversation with the person that we're talking to. If it's truly harassment, if it's illegal harassment, if it's discrimination or illegal discrimination, and we would have that conversation at that time. I really want people to come forward if they have a concern.
One thing that concerns me about wanting to purposely have some imprecision is that anything that is potentially vague or ambiguous is considered unconstitutional. So that would not be an approach I would suggest to embrace. And so I'm still concerned that I'm unclear who that reference is.
Well,
who's being bullied?
Okay,
Who's
first
doing
of
the
all, we
bullying?
do have policy 4300 coming up that does define unlawful harassment and sexual harassment. We have another policy, as we talked about earlier, 4200, that talked about discrimination. And within harassment as well, there's discrimination. And then we have a handbook that defines bullying. And in each of those policies, it refers to 4205. So 4205, as far as its numeric sequence, almost feels like maybe it's putting the cart before the horse, but it's just simply a number, and we put the complainant process up front, and then these other policies follow, such as 4300, unlawful harassment, sexual harassment, or like I mentioned, bullying is something new that we were asked to add onto our form. So we simply referenced the section in our employee handbook under that type of behavior, that if somebody wanted to complain, they would complain using 4205.
I think the bullying is okay. It might help to have a cite to where we have it referenced in another policy if that's the thought. But Tricia, on that first one, I agree with you. It just sort of is an odd change. The first sentence says an individual who believes, etc., and the second sentence says if the complaint. Like, can we just say if the individual? I mean, it's one sentence after another. Would it be fine just to say if the individual is uncomfortable
Absolutely.
discussing,
Yes.
rather than using the term?
Because have they filed a complaint at that? I mean, at what
Yeah,
point
and they
do
might not,
become
and it
the
might
complainant?
confuse them, but because it's one sentence right after another, you refer to them as an individual in the first sentence, I think we could just continue if the individual is uncomfortable in the second sentence, and then you wouldn't have that issue.
Absolutely. And
I like it better than employee, though. I'm glad you're thinking of changing employee, because it's not always an employee. so-
Exactly, and that was originally what was struck out, and then, of course, complainant was in its place, but I agree, individual does sound a little bit better, and it's still encompassing anybody, either internal or external.
Any other questions, concerns, changes?
I do like Lance's change. I just have to go down to number 1 still. And my suggestion would be to have an A, B, and C just defining discrimination, unlawful harassment, and bullying for clarity right there within that procedure, so that people don't have to go look at other policies. It's provided for them right here.
I think if you read the other policies, Tricia, I'm sorry, I think you would see that there's quite a lengthy definition,
Mhm.
and that would be the reason why. And we do encourage them. Now, we could reference the other policies here at that particular level so that they could go to them. However, we do reference the policy at the end as a cross-reference. But again, here's the issue of duplicating policies. When we go in and we change one and don't catch the other, then, and this is exactly what's happened, we miss something, and then we have two policies that are intended to be the same, but we didn't catch the changes in both documents. That's why I'm trying to keep it simple and be able to cross-reference each one so that when we make a change, it's much smoother and we're able to catch everything when we go to upgrade.
If it is defined in another policy, could we just, so when you say harassment, could you just put
Absolutely.
something that says defined in policy 4300? That's where, because that's
Yes.
where we define
Yeah.
it. Yeah, because that's a page long, and
After word bullying, just a phrase in there, as defined in policy 4300.
Absolutely.
In phrase, another comment, and add a signature.
I think that's good.
do you think that would be all right, Trish, instead of repeating it again, the same one?
Something to just direct them a little bit more clearly than cross-referencing at the bottom.
Sure.
That's a good idea. We could probably just put it in parentheses or
Yes.
something.
Defined in, yeah, or as
We do that
defined
in the
in.
employee handbook regularly, so certainly we can follow the same format. So, absolutely.
Okay. And that wouldn't require coming back to a committee meeting either, I want to think.
No. Anything else? Okay, then I would seek a motion to recommend to the full Board of Education the approval of revisions to policy 4205, complaint procedures, employment.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Abstentions? Motion carries. Item number 7, policy 4300, unlawful harassment / sexual harassment, employment.
Exactly. Now, this one, we put a little bit more work into. It was redundant, it wasn't clear. It also was a policy that, again, reiterated everything that was in 4205. And so that's the reason why at the very end of this policy, most of the verbiage was struck out, because we have the policy that we referenced. But what we were trying to do here is simply show the similarities but yet the differences between unlawful discrimination and the types of behaviors associated with that, and sexual harassment as well. Most of the behaviors are the same, but there's a few that are not. And so it was simply identifying what they are, giving a more up-to-date legal description of what, who the protected classes are, and giving an idea of what examples of sexual harassment or harassment would be.
Under sexual harassment, it says examples of prohibited conduct include, but then there are examples that don't appear to me to be really related all that much to sexual harassment. I guess they'd be harassment in general. One of them is inappropriate jokes about race. I would remove inappropriate. I don't think there are any appropriate jokes about race.
I think you caught that too. It's simply examples of harassment, unless sexual harassment is definitely identified on what it is.
Yeah, examples of prohibited conduct include but are not limited to the following. It is problematic that it comes under a heading of examples of sexual harassment, but they certainly are prohibited conduct.
Could you change that to examples of harassment / sexual
Yes.
harassment so that it would be more inclusive?
Yes.
So then people know that the list is going to contain both.
Exactly.
And then / inappropriate under number 2.
Yeah, I just think
race.
jokes about race is sufficient.
It says inappropriate jokes about race.
But there aren't any appropriate jokes about race, so I don't think we
you're
should
right.
reference inappropriate
You're
jokes
right.
about race.
Okay, jokes about race.
Anything else?
There's a typo in the first paragraph that's changed. The last sentence should read employment for continued or continued employment. The ORF is
The F is crossed.
I'm looking at a marked up copy. So which paragraph?
it would be the first changed paragraph in the last sentence.
I think that F is crossed out here.
Oh, I see what you mean.
Yeah, there's that F there, but it's got a cross through. I'm not sure.
Kind of hard to see, isn't it, for me?
Yeah.
I gotta
Yes.
zoom
It
in.
is.
Okay. Ready, let's see. Yes, it is crossed.
So I'm a little concerned about the categories that have been removed
Okay.
because it takes away a number of instances where we could still see unlawful harassment, sexual harassment.
What I was trying to do again was combine the different types of harassment as much as possible, but if you feel that there's something that needs to be left in, that's fine too. These are simply examples of what they could be or behaviors that would constitute harassment. And racially derogatory words, jokes
I'm so-
about race.
I'm sorry, I don't think I was clear. I'm in that third full paragraph where a number of categories have been struck from being included in this policy, such as pregnancy, sexual orientation, physical, mental, emotional, or learning disability.
When we're talking about unlawful harassment, and I'll go back, I had somebody retype this for me, and I'll double check that, but I simply took the words directly from the Department of Labor, verbatim. So when we're talking about harassment here, as far as unlawful or sexual harassment, I would tend to believe that creed is religion. We're talking about marital or parental status. That really wasn't addressed on the Department of Labor. Pregnancy, I think, fell under sex or gender. So again, I used their verbiage. These words, I think, were associated more as a descriptor of what those classes entailed.
Well,
And perhaps I could expand on that, saying quoting the Department of Labor and then add a little more detail if it becomes questionable.
I mean, these are separate categories.
Mhm.
Somebody just could be harassed as a pregnant individual, and that would be separate than gender. Not all females would be pregnant. I mean, it's different. Sexual orientation, there certainly could be harassment that would fall within this, and I'm uncomfortable removing that. And even individuals with different disabilities could be harassed for having that be, and they could be made fun of, they could
be, and I agree.
So how would they be covered otherwise?
The law defines the protected classes under this type of harassment.
Mhm.
Pregnancy is certainly a law that, we protect pregnant people for hiring or not hiring them and so on, but it doesn't fall on this particular policy. Yes, they could be, it's not sexual, it could be sexual harassment because they're female. So again, the sex part of it defines what type of sexual harassment could be. I know we're talking in circles in a sense, and I get where you're coming from,
Mhm.
but it's not something that was identified verbatim by the Department of Labor. And I simply wanted to put the law in here exactly the way that it was.
So when we state unlawful harassment, it's
Mhm.
important that there be a law stating that it's
Exactly.
unlawful. And we can't claim unlawful if it's not unlawful. can we?
Exactly.
Well, I mean, there's a Pregnancy Discrimination Act, so somebody could
Okay.
bring a claim
The
under that
pregnancy
federal law.
Yeah, and that falls under 4200 on why we would hire or not hire somebody. We can't discriminate we cannot discriminate against them for hiring.
I guess I'm unclear why
Okay.
we can't include.
Yeah, so that
We
wouldn't
can say
cover-
as a policy though that we determine that it's unlawful harassment. We can establish that policy.
Okay.
We could establish that it's something that we don't tolerate. That'd be different than saying it's unlawful.
Exactly.
Well, if there's a statute that can support us, then we can
Yeah.
interpret it as applying here.
Then maybe we need an unlawful and an unacceptable. As a person that
And
when I
that's
got
where-
pregnant, I had already been hired, I was working for the prison, and the warden came up to me and said, "Why would you want to have a child?" I mean,
And
that's
we have-
harassment.
Exactly.
But according to this, then that's acceptable.
No, it's not. We have a policy called bullying that's in our handbook, and we have a code of conduct in our handbook as well that very well describes that kind of behavior. It just doesn't belong in this policy.
And Tricia, just so I have this clearly,
Mm-hmm.
so the law that you referenced also isn't just about initial employment, it covers it'll cover the unwelcome conduct. Yeah,
Yeah,
okay.
but-
So then we do have protection in claiming that it's unlawful.
It's just concerning to me that we remove it from here. I'll give a personal example. I worked at a law firm as an attorney. I had a supervising attorney when I was pregnant who kept referring to me as mama until he was terminated for that behavior. And if you know it in any place, it should be working in a law firm. And it wasn't the case, so I would not have had a gender claim. It was a pregnancy discrimination. It was harassment. So I come at this from a couple different angles.
Well, I see no harm in adding it back in. And that, physical, mental, emotional, or learning disabilities just further describes the current last suggestion of disability or genetics. And it does no harm to expand upon that so that people are more clear on what they're not allowed to do.
Well, if it's not covered by law though, could we take the things that are being struck and say, reference those
Well, but I think
to
those
the
all are now
policy
covered
that
by
they would
law.
be covered under?
They're covered by law in a different policy.
Yeah.
They're covered by law on who can we discriminate or not discriminate against in hiring. That's a little bit
But this is
different.
different, though, than hiring.
Yeah, this is
Yeah.
being employed already and
Mhm.
Right.
And isn't there some debate about whether sex includes sexual orientation? So
It's
then,
all
wouldn't we
under-
want to define sexual orientation separately to make sure it's included as a protected class?
Well,
But
I
the law
didn't
already
because
does
the
include
Department
it.
of Labor didn't. And if we had a claim, we certainly want to be able to back up our law and our policy with what the actual law states, in my opinion. So, I thought it was safe to put exactly what the law entailed, so that if we did have a claim and went to an attorney, we have a policy that word for word describes what the law said.
Did you get a legal opinion on this?
No, we have not.
I would feel more comfortable with
Okay.
perhaps taking back some of the concerns. I mean, that's just me. I don't know if anybody else would, but I would feel comfortable having an attorney weigh in on this. That works for
Could
the
we
district.
bring this back next month after you have a chance to dig a little bit
Sure.
on that?
Yes.
Thank you.
No, I
Can
think
I
that
ask
might
a
be.
little clarification? I understand what everybody's saying. I wonder if the board is comfortable with the different forms of harassment, discrimination, and the different conditions being addressed in separate policies, because I'm hearing some interest. For instance, the policies we're addressing here are specific to employment, and so therefore is not that they're not addressing all potential harassing events, but we have separate policies. I understand you saying addressing those events. So and I know it's always difficult to cross-reference and make sure that we do updates where we have various references in multiple policies. So I guess, is the board comfortable with the separation, with different policies addressing different conditions, or are we looking for kind of a web, if you will, which makes it difficult, between all the different policies, that makes it maybe more user-friendly? I guess I'd have to kind of look at the language myself, because sometimes it also gets confusing. Are we talking about, who are we talking about? And so I'm not making myself very clear, and I apologize.
Well, I think
but I'm just wondering.
there's some value in having it all in one, but there's also some risk in having it be 20 pages long.
Right.
And what's the title? If so I think you could see it either way.
Okay.
I like Tricia's idea of getting an opinion on this. I think the safe route is just following the Department of Labor's definition, but I'd be interested to know from somebody who actually practices this type of law, what would be the advantage or disadvantage of us expanding on that. And, maybe there's some advantages to it,
Okay. Will do.
or maybe there's some big reason not to that I wouldn't know.
Okay. Thank you.
Yeah, I would definitely, if it can't be in this one because it's not under law, but it's still unacceptable in the Wausau School District, that they appear somewhere in our policies.
It's in
As
our
of the 4 women on the board right now, 2 of us experienced harassment while pregnant, and it wasn't related to being hired.
Exactly, and again, we have a policy that covers code of conduct, it covers bullying type of behaviors and the consequences for those kind of behaviors. So I feel that we're well-rounded and we have what we need in order to either investigate or assure that this kind of behavior is either taken care of or eliminated.
Okay, so we'll bring that one back next month. Item number 8, discrimination and / harassment form.
Yes, all I added was the link to that form. That was a recommendation. Again, that was something that was given to me through Mike Schwei, that there was, I believe Angie may have asked for it, or it might have even gone back as far as Jeff, but we wanted somewhere to represent that, because again, we have a policy in our handbook we bring now to 4205. We needed to have a form that they could fill out. So that's simply what we did. One other small change that I made to the form was under item number 5, the name and location of the alleged offender. The job title was missing, and I thought it would have been, it's much easier to know what that person does in the district, what their job title would be, so I did add that as well.
The one change I still would like to see is the bullying and hazing separated,
What do you mean separated?
to have their own box to tick.
They do.
Well, none of the one I'm looking
They're
at.
all one box under 3, bullying / hazing.
Item number 4, do you see bullying/hazing, third one to,
Right, she's
Yeah, I
suggesting
want them
bullying have a
separate.
box and hazing have its own box.
oh, I get it. Okay,
Sure, that's easy.
sure.
Anything else? I would seek a motion to recommend to the full Board of Education the approval of revisions to the discrimination/harassment form.
Is that with the separation of the bullying and hazing?
Yeah, I would think it would be.
Is that your motion?
Yes.
I'll
so
second
moved.
it.
Sorry.
All those in favor say aye.
Aye.
Opposed? Abstentions? Motion carries. Policy 4310, privacy of health information.
Okay, I am the HIPAA privacy officer, and so when I was looking at these policies, I decided I better look at this one as well and realized that it was significantly out of date. What was out of date were the plans that we identified. So all I did was go in here and change the types of plans that currently were affiliated with that would require some type of HIPAA action if necessary. Secondly, I changed our website from the old Wisconsin K-12 website to our current website, and then instead of calling somebody, contacting somebody.
Is there a way
Basically, that's it.
Is there a way to write that so that it doesn't have to be updated with specific plans, where you could just say the current health insurance plan for the Wausau School District, the current dental plan? Would that make sense or not? Or is it important that we be very specific?
Because we've been specific in the past, I felt that it was safe to follow suit. That's a great question. I do know that when we were audited for HIPAA, one of the things we did have to identify exactly was which plans and how private health information is handled and so on and so forth. I'm not exactly sure if we have to spell them out exactly, but because we always have, that's the reason that I did.
That makes sense.
You don't have to
Okay.
for each of the plans. You don't have to.
Okay.
I would think this would fall under that administrative change that just could be carried out and not brought to the board.
I would think so.
Done.
Okay.
So you want to strike the plans and just not identify
No, leave
them?
them, but you wouldn't have to bring the whole policy to the board if a
Exactly.
plan changes. That would be an
Exactly.
administrative change. Does that make sense?
I
If
think
that's
so.
the only thing that changes, you're not changing the,
Substance of it.
substance of the
Right.
policy, you're just
Absolutely.
changing a detail.
Okay, I will
So-
strike that from the policy then, and I think we will be fine. Then it doesn't need to come back, so.
Okay. All right, then I would seek a motion to recommend to the full Board of Education the approval of revisions to policy 4310, privacy of health information.
So move.
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Abstentions? Motion carries. And 10th item on the agenda, I seek a motion to adjourn.
So moved. Second.
All those in favor signify by saying aye.
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 Opposed? Abstentions? Motion carries. We are adjourned.